In September 2023, Jessie Clarke, General Counsel of the Office of International Law, travelled to The Hague with the Solicitor General to deliver oral submissions before the International Court of Justice in the Ukraine versus Russian Federation matter. In part 2 of our chat, Jessie tells us about this odd way of settling what is ultimately a war.
Yeah, look, you'd be right. I think many people are scratching their head when they see that this case has been brought off the back of the invasion and yet under the Genocide Convention. Why on earth? How does that work? So really, there are two reasons for it. One is a legal reason and one's a factual reason. The legal reason is, as I mentioned before, the International Court doesn't really have this comprehensive compulsory jurisdiction. It's an opt-in system, and Russia hasn't opted in. So there's no general consent by Russia to say, hey, any state that's got a dispute with us, you can take us to court and we'll resolve it peacefully. So Ukraine had to look for a specific provision of consent from Russia to ground its case. And there's a little article, Article 9 in the Genocide Convention, that basically says, look, states parties to this convention, if they have a dispute about the interpretation, application or fulfillment of the obligations under this convention, then the International Court of Justice has jurisdiction to decide the case. So that was the legal provision that Ukraine used to bring the case. Now, that's the legal answer, and that only gets you so far. The factual answer, though, is, and what many people sort of may not realise immediately, is that a lot of Russia's measures and indeed the invasion itself, taking place in the east of Ukraine, was justified on the basis that Russia said it was trying to protect ethnic Russians and Russian-speaking Ukrainians in the east of Ukraine. So President Putin, in fact, in his speech just before the invasion, what he called the special military operation, said that they were doing it to prevent genocide. And so it's on that factual basis that the case is actually in part, and in large part, about genocide.
Well, you said the SG delivered the speech on the day. How did you prepare for the trip, and what was your role?
Yeah, so I should give a shout out to Dr. Stephen Donoghue, Australia's Solicitor General. Look, it's a privilege and a pleasure to work with him across all Australia's international disputes. And this is what he does. He analyses complex legal issues and he crafts clear, concise, persuasive, written and oral pleadings. So I accompanied him as what's called Australia's agent in the dispute. So really it's a slightly less glamorous role, but an important one. It's a representational and a largely administrative role where I'm like a solicitor on the record for a domestic dispute. I'm Australia's kind of agent in the dispute. And of course, my role is very much supported by a wider team. We get to go and wear the robes and do that sort of stuff. And of course, that's exciting and interesting. But we're supported by a much broader team. So in the case of the counsel team, we had a terrific junior counsel, Dr. Kate Parlett, who's an Australian based in London, who was a terrific international law expert who supported us. And of course, DFAT has a major interest in this, and we worked very closely with them in developing our arguments. So absolutely a team effort, and it was great to see it all come together in that hearing in The Hague.
Is there coordination, though, between the applicants?
Yes, so all the interveners did coordinate. And in fact, that was a basis for Russia to object. They said, hang on, what are all you states doing? Ganging up on us. That's exactly what they said. Look, this is some coordinated effort. You're all just piling in on Ukraine's side. That's not appropriate for this dispute. And the court rejected that. There was a formal objection by Russia, and the court decided and said, no. Look, Russia, interveners are entitled to do this. And they drew a distinction between the motivations of states and their compliance with the statute. So on motivation, they rightly observed that states may get involved in litigation, bring it, defend it, intervene in it for a range of reasons.
Well, we have history with Russia, though, don't we?
Indeed, we do. Yeah. And it was no one's surprise,
yeah,
I think, that we would intervene in the way we did. So if we did it to support Ukraine in its efforts to hold Russia to account, that was our motivation. That's fine. What the key was, though, is we had to respect the limits of the intervention. And what that means is that we could really only intervene to provide our view of the proper interpretation of the Genocide Convention. And as long as we did that, we respected those bounds, and we did. If you're interested, you can read our submissions, and in some way, it's quite a dry technical argument at this stage of the proceedings. As long as we respected that, it was quite proper for all the interveners to intervene in the way they did and to coordinate among themselves.
Okay, but without crystal ball gazing, how do you think the intervention was received by the court and others generally?
Oh, look, it's always hard to tell, isn't it? And I guess the proof will be in the judgment itself when we see it from the court, whether it takes up some of the reasoning that Australia set forward. Look, being in the courtroom on the day, the judges seemed engaged. No one had fallen asleep, which is good. They were leaning forward. They had their pens in hand. So, you look at it in that sense, gosh, are they paying attention? And certainly they were. So we had some, immediate feedback that really showed us that we were hitting our objectives and hopefully will be influential. But we'll see what the court says.
With that, I saw that the Vice President of the court is actually a Russian national. Now, do you think that's going to have any sway on the outcome, or was that noted at all?
Yeah, look, so a bit about the judges on the ICJ, because that's an important question. The first thing is that there are 15 of them. So it's a massive court.
I saw the video, it takes a while to get going.
And the Attorney General has appeared for us in the Whaling case, and comments like, being an owl, you're looking hard left and then hard right to sort of, try and maintain eye contact with the bench. But look, really, the way the court is comprised is under the statute, it's got to represent the major legal traditions and sort of the regions of the world to have that kind of international legitimacy. So we typically see judges from a range of countries and from a range of reasons, and not always, but typically all the permanent members of the Security Council have had judges on the court, and that's sort of buying into its functions, its role, and its legitimacy. So it's common to have a Russian judge on the case. Now, what was interesting is, although he participated fully in the case, there was the question of whether to admit the interveners, the states who wanted to intervene, as I was talking about before. And interestingly, the president was an American. She stood aside from presiding over that bit of the judgment, because America had applied to intervene. Then it went down the line. So the Russian vice president stood aside, because obviously Russia's a party to the case. So it was about the sixth judge in seniority who actually was sort of presiding for that aspect. So there are ways in which the court can deal with any sort of obvious questions of an apprehension of bias by any judge, and there are rules about that. But to have, 15 judges, including a Russian judge, is not at all unusual. But can I tell you about one other weird feature of the International Court? So this is a case between Ukraine and Russia. Russia's already got a judge on the court, as you said. Well, so is that odd for Ukraine? And what the court statute allows is where there's not a national of a party that's before the court, they can appoint what's called a judge ad hoc. So Ukraine actually appointed their own judge to sit with the 15 others to sort of round out the full nationality of the bench. And so by appointing that judge ad hoc, there are in fact 16 judges hearing this case.
But that would also negate any sort of bias if one was...
That's, I think, part of the perception issue, but it's also sometimes important that the court be aware of particular dynamics or peculiarities of a national system. And it's always thought that a judge ad hoc can kind of translate some of that for the wider bench. And so it's a common practice before the International Court of Justice to have these judge ad hocs appointed by the parties. They're independent, of course. They affirm their oath, their judicial oath in taking office, but they do allow that kind of translation of any domestic particularities. So the wider bench might be aware of them.
Okay, so what happens now?
Well, so the hearing that we attended in The Hague was just about jurisdiction. So did this anchoring of the case in the Genocide Convention work? That's really the question before the court at the moment. Now, interestingly, the court's already tipped its hat at that a bit, because there was a provisional measures hearing in this case. What does that mean? Provisional measures are like an injunction proceedings. So the parties were looking for kind of interim protection while the dispute continued. And Ukraine was successful in that. So the court has already found it has prima facie jurisdiction, and now it needs to consider whether it's going to confirm it. But so it's already tipped its hat a bit in that direction. It's up to the court. Of course, it could say, actually, having looked at it more closely, no, we don't. But it'll be for the court to decide that. And I expect we'll get a judgment in January, February next year.
So what happens then? You and the SG back on the plane?
Well, maybe. The first step will be, depends how it goes. So if the court says we have jurisdiction, it will proceed to what's called the merits phase. And if that's the case, Australia's declaration of intervention already addresses some of the merits of the case, which provisions of the Genocide Convention are going to be at issue. And we would expect that we'd be entitled to participate in a future hearing. So yes, maybe in 18 months, 2 years, we can do the follow-up podcast on what happened at the merits.
Oh, the podcast is always open for you. That's no problem there.
That'll be the issue that the court's going to grapple with, this jurisdictional one to start with.
Well, Jesse, that's an excellent summary of the great work the department's been doing in this space. Thanks for coming in today to share your story. If you've downloaded this podcast and you've got any questions for Jesse, or you'd like to make some comments about the podcast or future podcasts, you can contact the Attorney General's Department via the Contact Us section on our website. This has been the Let's Talk podcast. Thanks for listening.
justice to have these judge ad hocs appointed by the parties. They're independent, of course. They affirm their oath, their judicial oath in taking office, but they do allow that kind of translation of any domestic particularities. So the wider bench might be aware of them.
Okay, so what happens now?
Well, so the hearing that we attended in The Hague was just about jurisdiction. So did this anchoring of the case in the Genocide Convention work? That's really the question before the court at the moment. Now, interestingly, the court's already tipped its hat at that a bit because there was a provisional measures hearing in this case. What does that mean? Provisional measures are like an injunction proceedings. So the parties were looking for kind of interim protection while the dispute continued. And Ukraine was successful in that. So the court has already found it has prima facie jurisdiction, and now it needs to consider whether it's going to confirm it. But so it's already tipped its hat a bit in that direction. It's up to the court. Of course, it could say, actually, having looked at it more closely, no, we don't. But it'll be for the court to decide that. And I expect we'll get a judgment in January, February next year.
So what happens then? You and the SG back on the plane?
Well, maybe. The first step will be, depends how it goes. So if the court says we have jurisdiction, it will proceed to what's called the merits phase. And if that's the case, Australia's declaration of intervention already addresses some of the merits of the case, which provisions of the Genocide Convention are going to be at issue. And we would expect that we'd be entitled to participate in a future hearing. So yes, maybe in 18 months, 2 years, we can do the follow-up podcast on what happened at the merits.
Oh, the podcast is always open for you. That's no problem there.
That'll be the issue that the court's going to grapple with, this jurisdictional one to start with.
Well, Jesse, that's an excellent summary of the great work the department's been doing in this space. Thanks for coming in today to share your story. If you've downloaded this podcast and you've got any questions for Jesse, or you'd like to make some comments about the podcast or future podcasts, you can contact the Attorney General's Department via the Contact Us section on our website. This has been the Let's Talk podcast. Thanks for listening.